Appeals for the state of Utah is now in session.
Good morning and welcome to the Court of Appeals today. I am Judge Michelle Christensen Forrester. With me on the panel today are Judges Gregory Orm and Judge Ryan Harris. And pursuant to the Chief Justice's administrative order dated March 21st of 2020, we are conducting today's arguments remotely so that we can continue our mission critical work and do our part to prevent the spread of the virus. We are hearing one argument, and that is in the matter of Pipkin and others versus Acumen. Of course, counsel, you should stay seated, but if you wouldn't mind, please entering your appearances for the record.
Yes, for appellants, I'm Seth Needs.
And Todd Weiler for the appellee, Daryl Acumen, who's also watching.
Thank you, counsel. As you may know, we're doing this remotely and we are recording. If we encounter any technical difficulties, please let us know and please forgive us. We're still sort of in the beginnings of these procedures. You'll notice that the clock is visible up on the left-hand side of your screen. And if you haven't already, if you could make sure you're in the grid mode so that you can see all the pictures of everybody. We will proceed, and a few things to keep in mind. When you're not arguing, if you could please mute your microphones and turn off your cameras. We like to see your faces, but I think it's easier for us if the judges are just the ones that are visible. And we'll do our best to keep our microphones off as well, unless we have a question. And if we do have a question, we'll try and signal either with our hand or maybe you'll see us move to turn on our microphones. So try and do your best. We won't interrupt your arguments if we can help it, but try to do your best to keep us in your perspective so that you can know if we have a question. If anyone of you loses audio for any reason, please, let us know or send a chat message or whatever, so that we do not want somebody not to be hearing. We are live streaming and recording just as we normally do. So just as you do in the courtroom, please state your appearance each time you begin to speak so that we know who's speaking. And with that, Mr. Needs, I see that you've reserved 4 minutes for rebuttal.
Correct, yes.
And you can begin anytime.
Okay, thanks. Well, may it please the court, my name is Seth Needs, and I am counsel for the appellants. The district court ruled against appellants in summary judgment is principally because the court found that appellees' defamatory statements were not about appellants. And let me just state first, I'd like to address the issue of defamation first. There were several issues that the court ruled against, and I'll just address the defamation first. As I briefly describe how the appellants meet each of the elements of defamation, I believe it will become clear that the district court erred on the point that the plaintiff, that appellee did in fact refer to appellants when he made his defamatory statement. First, appellants have alleged, and the record shows, that appellee published false and defamatory statements about the Gang of 51. When looking at appellee's emails at issue, I believe it is clear that appellee accused the Gang of 51 of committing a crime by violating Section 20A of the Utah State Code. This is discussed at length in the appellant's brief, and I have no... Yes, go ahead.
I have in the back of my mind, and I didn't look into it deeply before the oral arguments, and perhaps I should have, that at least for some categories of defamation and at common law, the crime of which plaintiffs are accused has to be one involving moral turpitude. The classic examples being prostitution, dishonesty, fraud, and the rest. In the context of this election debate, and with the overlay of First Amendment protections, is this really the accusation of the kind of crime that would trigger the sort of damage to reputation that our defamation laws are designed to protect?
Yes, I believe. And when you look at, let me see here. I'm looking at Larson. There's a Utah Supreme Court case, Larson v. Cisco Corp., where they define what defamation per se actually is. And it includes a number of cases. One is, you're correct, one is actions of moral turpitude, but it also specifically mentions any type of criminal conduct. And so in this case, I would argue that because, at least according to the Utah Supreme Court, because the appellee accused them of criminal conduct, I would say, according to at least Larson, that qualifies for a defamation per se. And so with that in mind, speaking about what the accusations of appellee, when I went back and looked at the record, I didn't find that appellee actually disputed that he made allegations accusing the Gang of 51 of committing a crime and acting illegally. And I also haven't found any testimony in the record where appellee disputes the fact that his statements accusing the Gang of 51 of committing a crime or acting illegally were false. And even if there were such testimony, the falsity of these statements. Oh, go ahead. Sorry.
Yeah, Mr. Needs. So as far as I can tell from your briefing, the thing, and perhaps even the only thing your clients are alleging is defamatory about these statements is that it accuses them of criminal or illegal conduct. Do I have that right?
Yes, correct.
Okay, and then I thought that was the case, and let me ask a couple of follow-up questions. So, what is it that in the email Mr. Acumen sent out, what is it that he is saying is illegal? Is it the vote cast by the Gang of 51, or is it the bylaw that eventually gets passed by the SCC?
So I think that's a great question. I think that's something that needs to be pointed out. So what appellants are claiming, and what they've addressed in the brief and also the amended complaint, and also a couple of the declarations that have been filed with the court that are in the record, what appellants are claiming is that appellee accused them of criminal conduct because they voted for the bylaw. And I think, and this is explained in the brief, I think as you go and look at when you go and actually analyze the emails that appellee sent out, I think it's clear that yes, that's all. That is exactly what he is accusing them of. He's accusing the Gang of 51 of acting criminally for voting for the bylaw.
But what criminal statute does he allege has been violated by whatever this stunt is? He calls it a stunt, and he says it violates election law in Section 20A. And I guess I would like your thoughts on exactly what it is that's illegal there, or that he's claiming or alleging is illegal there.
Well, I think
it has to be the bylaw, doesn't it? I mean, isn't that what would violate election law if Mr. Acumen were correct? It's the bylaw itself.
I don't think so. And even if the bylaw was illegal, I think when you actually read the text, he's specifically in the email, he's not saying that that necessarily his focus necessarily isn't that the bylaw is illegal. If you look at the email, he's specifically saying that because the SEC voted for this, they're the ones who violated the Section 20A. And then he also goes on and said that the Gang of 51 acted illegally. So I think that when you look at the email, the whole point of the email is that these members, these Gang of 51, these are they violated the law, and that they could be punished, up to 6 months. It's not the bylaw that they can be punished. It's the SEC members who can be punished.
Well, let me change the hypothetical on you. Let's assume that they only got 3 votes for this bylaw, and that it was voted down, 98 to 3 or however many to 3.
Right.
The 3 votes in favor of this bylaw wouldn't actually have enacted anything. There would be no bylaw because it was defeated. Would those 3 votes violate something in Section 20A of the Utah State Code?
Well, I'm not even. I don't think so. But I think the point is that it's not appellants who, it's appellee who is making the accusations. And so I think the focus needs to be on the fact that regardless of what happened at the SEC meeting, nothing happened illegally. And I think the focus needs to be on the fact that it was appellee who leveled the accusations of criminal conduct. I think that's the point that needs to be looked at or focused on.
Well, I think that's right. That's a fair point. But the criminal, it only becomes criminal once it passes, right? I guess that's the point I'm trying to get at. And if it only becomes criminal once it passes, it seems like it's the SCC doing the acting rather than the individual members who are casting the votes. Does that make sense? Do you understand what I'm getting hung up on there?
I'm not sure I'm following that.
Well, go back to the hypothetical. You only have 3 votes.
Right.
It gets voted down. There's no bylaw that actually passes that could be asserted that it is violative of Utah election law. Let's say an email goes out in that situation that says, hey, please contact these 3 in case this ever comes up again. What they're voting for might be illegal. Would that be defamatory?
Well, if I think what would be defamatory is if appellee accused them of committing a crime and that accusation was false, that would be a defamatory statement regardless of, I think that's the point. I think the point that we should focus on is the fact that they didn't act criminally, but appellee accused them of acting criminally, and that was false, and that's a false accusation. That makes sense.
Can I come back to the robust political debate and controversy in which all of this arises? I mean, it occurs to me that we very often, especially in national elections, will have one candidate or another accuse his or her opponent of nothing less than treason. And treason is an exceedingly serious offense defined rather precisely in our Constitution. But I don't know that the person accused of treason in the context of a political debate would have a defamation action against the person who claimed that, because I think it would be understood in context. Well, what I mean was he seems to be kind of on the disloyal side. He's not really embracing the view of our country that I have in mind. And even without all that explanation, don't those who hear those kinds of allegations in the political arena sort of necessarily take that with a grain of salt?
Well, I think it depends on the context. If there's a back and forth and people are going back and forth in a political context, arguing in a public setting, and both are throwing accusations at each other, I think it's possible, that people could say, oh, they're just doing that. I think this is a very different situation. The appellants never accused appellee of doing anything. This was a direct attack on appellants, and appellee specifically accused them of committing a crime. And if we were to let that go, there was no basis to it, and it was false. And because of that, I think it is clearly could cause damage to appellants and be subject to liability. I see my time's up. I'll defer the rest for later.
Thank you, Mr. Needs. Oh, we have Judge Orm back again. Mr. Weiler?
Thank you. Thank you very much. And I appreciate the well-prepared. It's obvious that all 3 of the justices are well prepared with the facts. So I won't spend any time on that. I will note that I think that the timing of this argument is particularly, I think it's interesting because of the political conventions last weekend, and this very issue of this disputed bylaw is back in the news because several of the candidates who will ostensibly appear on the primary ballot did collect signatures in violation of this rule, and I think everyone's waiting on pins and needles to see if there's going to be a legal challenge to that. I just want to, first of all, highlight that in his email, the appellee wrote, "If you agree with me, please contact the SEC members responsible for this action." This is clearly related to the business of the party. The SEC, as you know, is the governing body of the party. The members of the SEC represent the members of the party at large. There's about 600,000 registered Republicans in Utah. There's only about 180 members of the SEC. And I think it's important for context to note that every member of the SEC went to a political convention, stood up and gave a speech and asked to be elected to this governing body. And this is all part of political speech, all part of the political process. And the allegedly defamatory statements that Mr. Acumen made were made in the context of a robust debate, and they're not facts that are capable of being proven false, which are required element of the claim. Yes, sorry.
And maybe you're just about to get there, but can I have you focus in on Judge Harris's question about what was the act that at issue here? What was the statement at issue here? The email itself does say, because this stunt flouts current election law, it constitutes a Class B misdemeanor. And isn't the stunt the actual voting for the bylaw rather than the bylaw itself?
Let me just start off by saying I think that the whole statement that this violates and is a Class B misdemeanor, I think that that's clearly an opinion from a non-lawyer. But the question is, I think the stunt is the vote for the bylaw, and I think the stunt in and of itself is the bylaw. I mean, to get into the weeds for a moment, the political parties in Utah have to certify every 2 years with the Lieutenant Governor's office whether they're going to be a qualified political party or a registered political party. The Utah Republican Party has always certified, well, since the enactment of Senate Bill 54, that it's a qualified political party, which means that it allows the gathering of signatures. And also the state party, the party bylaws and constitutions say that they're void if they violate the law. And as you know, because it's in my brief, the Supreme Court has ruled that it's the Utah Supreme Court, that it's the candidate under the existing law, not the party that gets to decide which path. And so I think the stunt can be not only the drafting and the implementation of the bylaw, but also even a vote for the bylaw. I think it was a stunt because it's more symbolic. It was designed to send a chilling message to candidates saying, if you pursue this legal option, you may be stripped of your party membership. And so I think it could arguably go to both. I'm not sure that necessarily helps or hurts the defamation claim, but I do want to emphasize the fact that he's arguing that this is a Class B misdemeanor. That is clearly an opinion. That's something that nobody receiving the email could reasonably ascertain. There's no body of law on whether you vote for the bylaw or whether the bylaw is enacted or even enforced, if that is something that would be classified as a misdemeanor. And I think it's clear probably to all of us that if there was a Class B misdemeanor, it would be the party committing the crime, not the individual members who voted for it.
Mr. Weiler,
yes.
That's exactly the point I was trying to drive at with my question to Mr. Needs. If it were a Class B misdemeanor, what's the crime? And the crime seems to me necessarily to have been one committed by the state central committee.
Yeah.
Not by the individual members who cast the vote. I'm unaware of any election law that tells members of a deliberative body that it might be a crime to cast a vote in a certain way. What might potentially be violative, and again, this is, as you point out, potentially a matter of opinion, but what might be violative of election law is the actual bylaw, right?
Yes.
Am I misunderstanding that?
No, I think it's not only the bylaw, but I think more importantly, it would be the enforcement of the bylaw. I think having the bylaw on the books is one thing, but if the party actually enforces it and tells, I'll just use an example. Thomas Wright is running for governor right now. He failed at convention. He was in the top two, but he has signatures. So if the Utah Republican Party stripped him of his membership today and announced, he's no longer Republican, he can't participate in the primary, that action alone, I think, would trigger the allegation of a Class B misdemeanor. Not even passing it, but I think enforcing it, in my mind, would be the actual trigger. Okay, so in any event, I think that the one real outstanding red flag to me is the plaintiffs have never tried to show that the bylaw wouldn't trigger a Class B misdemeanor. So I'm arguing here that truth is a defense. I think that we can probably all agree that voting for the bylaw probably wouldn't trigger that on a legal basis. But again, I think that in the context of a robust political debate, the appellant has his right to express his opinion that the vote in and of itself would violate the bylaw, even if that opinion may not bear any legal cognizance. But the other thing is whether I think it exposed the appellants, the plaintiffs, to hatred, contempt, or ridicule. They did receive some mean emails. They also received, the record reflects, some congratulatory emails of the 600 emails that, and I just so we're clear, the appellee created a link. So if someone clicked on the link and replied, it would automatically reply to all 51 people. And so, I think the argument, I'm going to advance the argument that many of these people who replied didn't know exactly to whom they were replying. And so to say that some people were angry, I think they were angry at this idea rather than the individual plaintiffs, some of whom might have been known to the repliers and many of whom probably were not known to the repliers. I also think it's worth noting that these emails that Mr. Acumen sent out, they were sent to delegates, people who had gone to their precinct caucuses and were elected. They weren't sent to the public at large. In any event, the whole crux of this appeal is that the trial court did something wrong by dismissing this on a motion to dismiss or motion, it will convert to motion for summary judgment. And I just wanted to point out that the West versus Thompson newspapers case makes it very clear that the First Amendment interests inform a strong policy that favors disposing of legally defective defamation claims like this one at an early stage in the litigation to prevent chilling free speech. And courts routinely decide First Amendment issues as a matter of law rather than letting those issues go to trial. And that's exactly what happened here. And I would argue that the trial court was well within its discretion to do that. Also, of course, the tort of defamation is intended to protect an individual's interest in maintaining a good reputation. All of the plaintiffs were, all of the appellants were in support of this policy change of the party. And so what they're being accused of is exactly what they were supporting. And that's a policy of excommunicating or disfellowshipping members of the Republican Party who committed the crime, and I'm using that in not literally of supporting kicking out people who chose to access the primary ballot through signatures. So with that, let me continue on that. Well, I've already covered that these are lay opinions. Let me just forward in my, I also believe that the business interest exception applies because this was the business of a party. Yes, the Utah Republican Party is a private organization, but it's also an association that's filed and registered with the Utah Department of Commerce, as pointed out in my brief. And the business of the party is to make policies and to say that bylaws are not the business of an organization. I don't know what else could be the business of an organization other than talking about bylaw changes and debating bylaw changes and making bylaw changes. We haven't touched on the electronic communications very much, but I wanted to point out two things. Number one, the emails of which are complained of were actually sent by members of the party who the SEC members were supposed to be representing. Mr. Acumen did not send 600 emails. People clicked on that link, and then every one of the 600 emails, or at least the majority of them, were sent by different people. I mean, I'm not saying that nobody replied twice. The other thing is we do have this business interest exception. So I would ask the court to uphold the trial court's ruling on the electronic communications harassment. And even if everything was said was true, I think the court can take judicial notice of the fact that 600 emails over the course of 3 weeks or so is not going to prevent someone from conducting their ordinary business or responding. And I will, yes, Justice Orm.
No, go ahead and finish your thought. This was
I was going
to get to a convenient breaking point.
Yeah, it's not uncommon for elected officials on the state or federal, even on the city level, to receive 600 emails a month from the people they represent.
I was just going to inquire about, I don't remember this case being cited in the briefing, and it isn't binding on us because it is the decision of a single federal court judge, albeit a judge who happens to be a former member of the Utah Supreme Court. I don't think that gives her any official particular insights, but interestingly enough, in 2018, Judge Parrish, in a case called Nunes versus Rushton, found that despite what might be some implications in subsection 5 of the applicable statute, she concluded that it wasn't clear enough and there was no private right of action under the statute. I wondered if you were familiar with that case, and if so, whether one way to affirm Judge Connors on any basis that suggests itself in the record would be that if we happen to agree with Judge Parrish that the law is not clear enough to allow a private right of action.
Yeah, unfortunately, I'll admit I'm not that familiar with the Nunes or Rushton case, but I will agree in concept. I mean, being familiar with the statute, that it certainly isn't clear that there's a private cause of action there. And I think that obviously the court can look outside of its own decisions to, for analogous rulings and analogous, I don't know, dicta or whatnot. So I
right.
think that would be applicable.
The beauty of something like that, if we find it persuasive, we can cite it and rely on it and endorse it. If we don't find it persuasive, we can put it in a footnote or just ignore it entirely. But I did want to raise the existence of that case and the possibility, at least, that despite what might be the negative implication of subsection 5B, at least one judge has found no private right of action under the statute. It's just not clear enough.
Yeah. Great. If there's no further questions, I'll conclude my presentation.
Thank you, Mr. Weiler. Mr. Needs?
Yes. Okay. Well, I think what's very important for us to realize in this case is that this is a matter of summary judgment, and there were a number of things in the record that and accusations by appellants that appellee never disputed, and I think this is very important to this issue. One, several things that appellant has not disputed is: one, appellant has not disputed that he accused the Gang of 51 of criminal and illegal conduct. That was never disputed. It's disputed. It's true that appellant said the bylaw was illegal, but he never disputed the fact that he accused the Gang of 51 of criminal and illegal conduct. I think that's very important. The other thing is that appellee has not disputed that he provided a link of each member of the Gang of 51 in those emails. And in that link, the names of each of those individuals included the names of the appellant. So appellee specifically mentioned who the appellants were and specifically mentioned that they were members of the Gang of 51. The other thing is appellee has not disputed the fact that he accused the Gang of 51 of criminal conduct negligently or knowingly or with a reckless disregard to the truth. That was never disputed in the record by appellee. And also, it was never disputed by appellee that appellant suffered damages as a result of appellee's defamatory statements. I think those are all very important things that we need to look at when we look at this summary judgment ruling, that there were many things that were not disputed by appellee in the record. The one thing that he appears to dispute is, as it relates to defamation, is the fact that he never referred to appellants in his email. But I think when we look at the Utah Supreme Court case, it's Pratt v. Nelson, yes. I think it clearly shows that it doesn't matter if he specifically named them in the email. What's important is that he referred to them in the email by linking their names and naming them in that link as members of the Gang of 51. So I think the fact pattern in this case is clearly related to the fact pattern in Pratt v. Nelson. And so when we look at all that, I think it's very clear that at least we need to let the jury decide these issues. This needs to absolutely go back to the district court, let it go through the process, and let these things be decided in the district court. Go through discovery. Let the appellants have their time in court. Let them go before a jury, and let them have discovery to really get these issues and facts hammered down. Because clearly there are clearly facts missing. There are clearly things that appellee has not disputed, and there are clearly issues that should be decided by a jury and by the fact finder in this case. I see my time's almost up. Are there any questions for me, Your Honors?
No other questions on my part.
I'm not sure if I can. I'll end it at that.
Thank you, Mr. Leeds, and thank you, Mr. Weiler, for your arguments today. We truly appreciate them, and thank you for being willing to undertake this more virtual process with us. We will take this matter under advisement and render a written decision as soon as we can. And that will be excused. Thank you.